Okay, learning unit 6, crimes against public welfare. We'll start there at the introduction.
Extortion 6.1 INTRODUCTION. In this learning unit, we discuss a number of offenses against the public welfare, such as the common law crimes of public violence and extortion, and the statutory offense of corruption. 6.2 Public Violence Joubert, Chapter 5.6.2.1 Definition. Public violence is the unlawful and intentional performance by a number of persons of acts, or an act, which assume s. serious proportions and is intended to disturb the public peace and order by violent means or to infringe the rights of another. 6.2.2 Elements of the crime. The elements of the crime are the following: 1. An act, 2. Performed by a number of persons, 3. Which assumes serious proportions, 4. Which is unlawful, and 5. Intentional, and, more specifically, includes an intention to disturb the public peace and order by violent means, or to infringe the rights of another. 6.2.3 The object or interest protected. The interest protected in the case of public violence is the public peace and order. Saley 1938 TPD 139. 45 CRW 2603/16.2.4 Joint action. The crime cannot be committed by an individual acting alone. The public peace and order must be disturbed by a number of persons acting in concert. It is impossible to specify the number of persons required. This will depend on the circumstances of the case, taking into account factors such as the seriousness of the threat to peace and order. In Terblink 1938 EDL 112, VE persons were considered souciant, while, in other cases where the disturbance of peace and order was not serious, for example as a result of the limited scope and duration of the disturbance, 6, 8 and 10 persons were considered insouciant for the commission of the crime. Mkunu 1938 TPD 229, Saley Super and Xumalo 1960, 2. SA 442, T, respectively. Those participating in the disturbance of the peace must act in concert, that is, with a common purpose. Wilkins 1941 TPD 276, 289, Whitehead 2008, 1, SACR 431, SCA. The crime can be committed both in a public place and on private property. Seal 1958, 1, SA 144, N, 152F, Sikapatsi 1960, 2, SA 430, T, 435 to 437. The participants need not be armed. The act must be accompanied by violence or a threat of violence. Wilkins Super 289, Seal Super 152G. The crime is committed even if there is no actual disturbance of the public peace and order, or no actual infringement of the rights of another. It is souciant if the action is aimed at the disturbance of the peace or the infringement of the rights of another. Valace 1938 NPD 239, Sigapatsi Super 433, E. 6.2.5 Examples of conduct. The following are examples of behavior amounting to public violence. Faction GHTS Joint resistance to police action by a group of persons rioting. Violent coercion of other workers by a group of strikers. Disrupting and taking over a meeting by a gang. 6.2.6 Serious proportions. The crime is committed only if, in addition to the other requirements, the action of the group assumes serious proportions. One of the reasons for the existence of the crime is that the safety of persons not involved in the disturbance is threatened, and this will be the case only if the disturbance is serious. Chayachini 1918 TPD 23, 2930. Although this requirement may be somewhat vague, it is nonetheless essential to distinguish public violence from cases of, for example, rowdy behavior and family feuds which do not threaten public peace and order. Whether or not the act can be classified as serious will depend on various factors, or a combination of them, examples of which would be the following: 1. The number of persons involved, 2. The time, 3. The place. 46. 4. The duration of the disturbance. 5. The cause of the disturbance. 6. The status of the participants. 7. Whether or not they are armed. 8. Whether persons or property are injured or damaged. 9. The way in which the disturbance is settled, if it is settled. 6.2.7 Unlawfulness. Both the actions of the group of persons or crowd, as such, and the actions of the individual accused must have been unlawful. The participation of the individual may, for example, be justified on the ground of compulsion, Samuel 1960, 4, SA 702, SR, while the behavior of the group may be justified, for example, by private defense, Mathlala 1951, 1, SA 49, T, 57 to 58, 6.2.8 Intention. Intention is the form of culpability required. The individual accused must have been aware of the nature and purpose of the actions of the group, and her participation in the activities of the group must have been intentional, Aaron 1962, 2, PHH 177, SR. Furthermore, a common purpose of disturbing the public peace and order must exist between the members of the group. Activity. A right-wing political party holds a meeting in a hall. The leader of the party, Y, has, on numerous occasions, made derogatory remarks about gay people. A large number of gay rights activists decide to break up his meeting. Almost 150 members of this group are gathered in front of the hall on the evening the meeting is held. As people arrive for the meeting, the activists obstruct the entrance to the hall. Y, the leader of the political party, calls the police on his cell phone. The police arrive with dogs and tear gas. They request the protesters to disperse peacefully. One woman shouts that the police will have to remove her forcefully. The others all agree with her. Because the crowd refuses to disperse, the police throw tear gas canisters and the protesters run away. The protesters are charged with public violence. Their legal representative argues that the actions of the protesters were not serious enough to justify a conviction of the crime. You are the state prosecutor. What should your response be to this reasoning? 12 Feedback. You will say that actual disturbance of the peace is not required for a conviction of this crime. All that is required is that the actions of the protesters be intended to disturb the public peace and order. You will argue that there is ample evidence before the court in this respect. You could also argue that, because the entrance to the hall was obstructed by the protesters and tear gas was used to disperse the crowd, the actions were serious enough to justify a conviction of public violence, Saley and Ngubain. 47 CRW 2603/16.3 Corruption. Joubert, Chapter 5.6.3.1 General. Even if a country has the most remarkable acts and legal rules, it will fail in its endeavor to create a just and prosperous dispensation for its citizens if corruption reigns. Corruption erodes moral values as well as trust in the authorities and authoritative organs. It leads to the malfunctioning of the public and private sectors of the community and provides a breeding ground for organized crime. Ngumbna mentions in his book Corruption and Human Development in Africa that the reason why corruption is so rife in Africa is that it is often not regarded as a crime at all. Nepotism, where friends and family are favored over others, particularly by giving them jobs, is seen as a way to help your family, which is to be encouraged. In Nigeria, it is regarded as sharing the national cake where public OCE bearers graze to the Beni tea of their family, and Ngumbna's words. Having said that, it is acknowledged that the concept of Ubuntu has the meaning of Beni ting all, and not only those people close to the public OCE bearer. In South Africa, corruption was previously a common law offense known as bribery. From 1992 corruption was punished in terms of the provisions of the Corruption Act 94 of 1992. In 2004 this act was replaced by the Prevention and Combating of Corrupt Activities Act 12 of 2004.6.3.2 General and Specific Crimes of Corruption. The current 2004 Act creates a general, broad, and all-encompassing offense of corruption, as it is described in the Act. Various crimes in which specific corrupt activities are criminalized. The Act is very long and comprehensive, and it is impossible to set out in detail all its provisions. In the discussion that follows, emphasis will be placed on the general offense of corruption. In writing this act, the legislature followed a style according to which large parts of the formulation of the general offense have been repeated in the formulation of specie C offenses. In order to make it easier to apply the relevant section to a specie C class of persons or a specie C issue, the legislature then just added certain provisions. There is thus a great deal of repetition in the act. If one understands the elements of the general crime, it should not be difficult to follow the line of thought of the legislature when creating the specie C offenses. 486.3.3 The general crime of corruption, definition in the Act. Section 3 of the Act contains the formulation of the general offense of corruption. The section provides as follows: any person who directly or indirectly, a. accepts or agrees or oers to accept any gratification from any other person, whether for the benefit of himself or herself or for the benefit of another person, or b. gives or agrees or oers to give to any other person any gratification, whether for the benefit of that other person or for the benefit of another person, in order to act, personally or by influencing another person so to act, in a manner, I, that amounts to the a. illegal, dishonest, unauthorized, incomplete, or biased, or b. misuse or selling of information or material acquired in the course of the exercise, carrying out or performance of any powers, duties for functions arising out of a constitutional, statutory, contractual, or any other legal obligation to, that amounts to, a. the abuse of a position of authority, b. the breach of trust, or c. the violation of a legal duty or a set of rules, 3. designed to achieve an unjust end result, or 4. that amounts to any other unauthorized or improper inducement to do or not to do anything, is guilty of the offense of corruption. 6.3.4 Shortened definition of the general crime of corruption. If one applies the rules for analyzing sentences by provisionally cutting out the conjunctive words or phrases, the main sentence of the definition quoted above reads as follows: anyone that 15, a. accepts any gratification from any other person, or 16, b. gives any gratification to any other person in order to act in a manner that amounts to the illegal exercise of any duties, is guilty of the offense of corruption. It is not necessary for you to memorize the definition of the general crime in section 3 quoted above. In the examination we will not expect you to know the exact content of this section. However, you must know the shortened version of the section set out against the gray screen block, above, for the examination. 49 CRW 2603/16.3.5 Corruption by giver and corruption by recipient. Corruption can be committed in various ways. If one attempts to make statements about corruption which are applicable to all instances of the offense, one becomes entangled in long formulations that are not easily understandable. In order to overcome this problem, discussions on the crime usually distinguish between the two most important ways in which the offense can be committed. These two main categories are corruption committed by the giver and corruption committed by the recipient. Corruption is committed if one party gives gratification to another party and the other party accepts it as inducement to act in a certain way. Both parties, the giver and the recipient, commit corruption. The expression corruption by a giver refers to the conduct of the giver, and corruption committed by a recipient to the conduct of the party who accepted it. In the discussion of the crime that follows, the party who gives the gratification is referred to as X, and the party who accepts the gratification is referred to as Y. As will be explained later, it must be kept in mind that the word give also includes the following: the agreement by X to give the gratification to Y, or the offering by X to give the gratification to Y. The word accept, on the other hand, includes the following: the agreement by Y to accept the gratification or the offering by Y to accept it. In the act currently under discussion, the legislature not only distinguished between these two forms of corruption in the definition of the general crime, but also in the definitions of the specie C crimes. In section 3, quoted above, in which the general crime is dened, corruption committed by the recipient is discussed in the section marked A, while corruption committed by the giver is discussed in the section marked B. In principle, corruption committed by the giver is only a mirror image of corruption committed by the recipient. In order to avoid duplication, emphasis in the discussion that follows will be placed on corruption committed by the recipient. In the discussion of this form of the crime, the deterrent requirements of the elements of the crime will be identified and explained. 6.3.6 General crime of corruption. The crime committed by the recipient. 6.3.6.1 Elements of the crime. The elements of the general crime of corruption by the recipient are the following: 1. The acceptance by Y, the element of an act; 2. Of great I cation; 3. In order to act in a certain way, the inducement; 4. Unlawfulness; 5. Intention. Each of these elements will now be discussed. 506.3.6.2 The acceptance, conduct element. The word accept has a technical meaning because it includes a number of other acts that are not normally regarded as synonyms of accept. The legislature employs two ways to broaden the meaning of accept: the act provides, in S3a, for certain conduct by Y which precedes the acceptance, namely to agree to accept a great I cation or to OER to receive it. Follows from this provision that, in this crime, no distinction is made between the stem crime, main crime, on the one hand, and conspiracy or incitement to commit the main crime on the other. The act provides, in S2, 3a, that the words or expressions accept, agree to, accept, and OER to accept as used in the act also have the following broader meanings: 1. To demand, ask for, seek, request, solicit, receive or obtain great I cation. 2. To agree to perform the acts named under 1, 3. To OER to perform the acts named under 1. The following considerations toward Y no defense. 1. The fact that Y did not accept the great I cation directly but only indirectly. S3. Y does not have to accept the great I cation personally. The fact that Y makes use of a middleman to accept the great I cation affords her no defense. 2. The fact that Y did not, in actual fact, later perform the act which X had induced her to perform. S25. C. If Y had accepted the great I cation but the entire evil scheme was exposed and Y was arrested by the police before she could fulfill her part of the agreement with X, Y is nevertheless guilty of the crime. Therefore the crime is completed even if Y has not yet done what she had undertaken to do, expressly or implicitly. 3. The fact that the corrupt activity between X and Y was unsuccessful. This consideration affords neither X nor Y a defense. 4. For the purpose of liability, it is irrelevant that the state or the private enterprise concerned with the transaction did not sue prejudice as a result of X or Y's conduct. 5. The fact that Y accepted the great I cation but that she, in actual fact, did not have the power or right to do what X wished her to do, affords neither X nor Y a defense. S25. A. Therefore, if X gives great I cation to Y in the belief that Y will give her a driver's license, which she is not entitled to do as C rather than Y is empowered to make such a decision, this fact can afford neither X nor Y a defense. 6.3.6.3 The great I cation. The definitions set out in section 1 contain a long definition for the word great I cation. For the purposes of this course, you do not have to know this section or be able to quote it. The following are highlighted words or expressions which, according to the legislature, also mean great I cation. 51 CRW 2603/1. 1. Money. 2. A gift. 3. A loan. 4. Property. 5. The avoidance of a loss. 6. The avoidance of a penalty, such as any. 7. Employment. A contract of employment or services. 8. Any forbearance to demand any money. 9. Any favor or advantage of any description. 10. Any right or privilege. It is evident that great I cation has a very broad meaning in terms of the act and that it is not limited to tangible or patrimonial benefits. It is suggested that the word great I cation, as used in the act, is wide enough to include information, and even sexual favors, e.g. when a tracé au ser, Y, who has caught a woman, X, for atrocity ins, agrees or OERS not to prosecute X for her ins if he and X can engage in sexual intercourse with each other, W 1991, 2, SACR 642, T. Point 6.3.6.4 The requirement of inducement, in order to act, in a manner, a general Y must accept the great I cation in order to act in a certain manner. Stated differently, she must accept the great I cation as an inducement to act in a certain manner. In other words, she must have a certain aim or motive in mind with the acceptance. Be the aims. The legislature names a number of aims in considerable detail. Below, we give an abbreviated version of these aims, which you have to know for examination purposes. 1. In order to act in a manner that amounts to the illegal, dishonest, unauthorized, incomplete, or biased exercise of any powers, duties, or functions arising out of a legal obligation. 2. In order to act in a manner which amounts to the misuse or selling of information acquired in the course of the exercise of any duties arising out of a legal obligation. 3. In order to act in a manner which amounts to the abuse of a position of authority, the violation of a legal duty or a breach of trust. 4. In order to act in a manner designed to achieve an unjust end result. 5. In order to act in a manner that amounts to any other improper inducement to do or not to do anything. It is clear that these aims are denoted broadly and that they cover a very wide field. The fourth aim, to act in a manner to achieve an unjust end result, is formulated so broadly that it includes almost all the other aims. 52. See general principles of the aims. 1. In each instance, the expression to act appears. The legislature provides explicitly that an act also includes an omission. S2. 4.2. It is irrelevant whether Y plans to achieve this aim personally or whether she plans to achieve this aim by influencing another person to act in such a manner. See the phrase in S3 between B and I. Therefore Y may make use of a middleman to achieve the aim. 3. The aims apply in the alternative. It is sufficient for the state to prove that Y had only one of these aims in mind when she accepted the great I cation. 4. It is irrelevant whether Y accepted the great I cation for her own vanity or for the vanity of someone else. S3, A, and B. Therefore, the fact that Y receives money from X in a corrupt way with the aim to use the money to provide for her sick child affords her no defense. 5. The fact that Y did not in actual fact have the power to act in the manner in which she was induced to act affords Y no defense. S25a. Therefore, if Y receives money from X as inducement to give X a particular license, but it seems that a person in a higher position in the relevant state department or enterprise is actually empowered to decide who should be issued with licenses, Y is still guilty of the crime. 6.3.6.5 Unlawfulness. The element of unlawfulness is not expressly provided for in the definition of the crime, but must nevertheless be read into it. Unlawfulness, or rather the requirement that the act should be unjust is a requirement or element of all crimes. The general meaning of unlawful is against the legal convictions of society. It implies that Y's conduct must not be covered by a ground of justification. The following are examples of conduct which ostensibly fall within the ambit of the definitional elements of corruption, but are nevertheless not unlawful. 1. An act which would otherwise amount to corruption would most decidedly not be unlawful if Y acted under compulsion. 2. A person used as a police trap also does not act unlawfully if she agrees to receive great I cation from another person in order to trap that person into committing corruption. Ernst 1963, 3, SA 666, T. 668a, B. Gani 1967, 4, SA 203, N. 3. It is suggested that certain OCHALs or employees, such as porters or waiters, do not act unlawfully when they receive small amounts of money from the public as tips for services which they performed satisfactorily. Such conduct is socially adequate, it is not against the good morals or legal convictions of the community. 4. The same applies in respect of receiving gifts of a reasonable proportion by employees at occasions such as weddings or upon retirement or completion of a round number, e.g. 20 years, of work. A golden handshake which may involve a substantial amount of money may, depending on the circumstances, be another matter altogether. 6.3.6.6 Intention. It cannot be said that the legislature intended to create strict liability. In respect of the form of culpability required for this crime, it is clear that intention, and not negligence. 53 CRW 2603/1 is required. Words or expressions such as the following used in the section suppose the requirement of intention: accept, agree, OER, inducement, in order to, and design. According to general principles, intention always includes a certain knowledge, namely knowledge of the nature of the act, the presence of the denitional elements and the unlawfulness. Someone has knowledge of a fact not only if she is convinced of its existence, but also if she foresees the possibility of the existence of the fact, but is reckless towards it. In other words, if she is not deterred by the possibility of the existence of the fact and goes ahead with the forbidden conduct regardless, then her intention is present in the form of dolus eventualis. The act contains a provision which expressly applies the principle of dolus eventualis to this crime. Section 2.1 provides that for the purposes of the act a person is regarded as having knowledge of a fact, not just if the person has actual knowledge of a fact, but also if the court is satisfied that the person believes that there is a reasonable possibility of the existence of that fact, and the person has failed to obtain information to confirm the existence of that fact. The fact that Y accepted the Grati Cation without intending to perform the act which she was induced to perform awards Y no defense, S25, b. If Y, who is somebody who can decide to whom a tender should be awarded, receives money from X as inducement to award the tender to X, the fact that Y received the money without having had the intention to actually use her unions in X's favor, and accepted the money only to enrich herself, awards her no defense. Activity X, a cabinet minister, has a very high standard of living. He loves to buy beautiful clothes and to entertain lavishly. He also owes the bank a lot of money. He invites Z, a property developer who owns a number of OCES, for lunch. X suggests to Z that he, X, will make sure that the department that he is responsible for will rent OCES from Z. In return for this undertaking, Z must pay R500,000 into X's bank account. Z, who is a very honest man, says he will consider the OER. However, he goes to the Hawks and tells them that X has made him this OER. Consider whether X may be charged with corruption. Point 13 Feedback. Yes, X may be charged with the completed crime of corruption. The mere making of an OER to receive Grati Cation is sufficient to qualify as acceptance. X also OER'd to receive Grati Cation with the aim to act in a manner that amounts to the illegal, dishonest, unauthorized, or biased exercise of his duties. He abused his power as minister. His act was furthermore unlawful, and he had the intention to receive Grati Cation unlawfully. Therefore his conduct complies with all the elements of the OINS. 546.3.7 General crime of corruption, corruption by the giver. 6.3.7.1 General corruption by the recipient discussed above deals with acceptance by Y of Grati Cation given by X. Conversely, corruption committed by the giver deals with the giving by X of Grati Cation to Y. Corruption committed by the giver is but only a mirror image of corruption committed by the recipient. Instead of accept, which describes Y's conduct in corruption as recipient, the word give, which describes X's conduct in corruption by the giver, should be used. Because corruption committed by the giver is but a mirror image of corruption committed by the recipient, it is unnecessary to repeat once again in the discussion of corruption by the giver all the rules dealing with the OINS discussed above, namely corruption by the recipient. Therefore, the discussion of corruption by the giver which follows can be summarized very briefly except if indicated otherwise. All the principles applicable to corruption committed by the recipient are mutatis mutandis, in other words, by replacing the word accept with the word give in each instance, applicable also to corruption committed by the giver. It is more or less just in the requirement of the act that corruption by the giver is structured differently from corruption by the recipient. 6.3.7.2 Elements of the crime. The elements of the general crime of corruption are the following: 1. The giving by X to Y, the requirement of an act. 2. Of great I cation. 3. In order to induce Y to act in a certain manner, the element of inducement. 4. Unlawfulness. 5. Intention. 6.3.7.3 The giving of great I cation. The act consists of X giving great I cation to Y. The word gives has a technical meaning because, apart from give as in the ordinary meaning of the word, other acts are included which are not normally regarded as synonyms of give. The legislature uses two ways to broaden the meaning of give. 1. The act provides, in S3b, that certain conduct by X preceding the giving of the great I cation, namely, to merely agree to give great I cation or to OER to give it, also satisfies the requirement of an act. 2. The act provides, in S3b, that the words give or agree or OER to give any great I cation, as used in the act, also have the following broader meanings: to promise, lend, grant, confer or procure the great I cation, to agree to lend, grant, confer or procure the great I cation, to OER to lend, grant, confer or procure such great I cation. It is not a requirement for the offense committed by the giver that X should have succeeded with her plan of action. Therefore, considerations such as the following award X no defense. 55 CRW 2603/1 The fact that Y, although she perhaps gave the impression that she would accept the OER, in actual fact had no intention of doing what X had asked her to do. S25b. The fact that Y did not do what X requested her to do. S25c. The fact that Y did not have the power to do that which she was requested to do. S25a. The fact that Y rejected X's OER. The fact that Y agreed but thereafter changed her mind. The fact that Y found it impossible to do that which she had undertaken to do. 6.3.7.4 The great I cation. This requirement is the same as the corresponding requirement for corruption committed by the recipient and is, as has already been set out above in the discussion on that form of corruption. 6.3.7.5 In order to act in a certain manner, inducement. This requirement is the same as the corresponding requirement for corruption committed by the recipient. The wording of the section dealing with this element of corruption committed by the giver is not very clear, but it is nevertheless clear that the legislature intended to say, anyone who gives any great I cation, in order to induce the recipient to act, in a manner that. The words printed in italics, which express the meaning of the provision more clearly, do not appear in the text of the section, but are implied. In Sheikh and Others 2007, 1. SACR 142, D, and 2007, 1, SACR 247, SCA, the accused was convicted of corruption in terms of the predecessor of Section 3 of Act 12 of 2004, S1 of the Corruption Act 94 of 1992. There is no substantial difference between the wording of the previous section and that of the current Section 3 of Act 12 of 2004. The elements of the previous offense, S1, 1, A, I, in relevant part, were I, the giving, includes OER to give and agree to give, 2, of a benity that is not legally due, 3, to a person in whom is vested the carrying out of any duty, by virtue of her holding of an OCE, etc., 4, with the aim of enuncing that person to do an act, or omit to do some act, in the performance of that duty, v. Unlawfulness. 6. Intention. X was charged on 2 counts of contravening the act in that, from October 1995 to September 2002, he had made numerous payments to Y with the object of inducing the latter to use his, Y's, name or political unions in favor of X's businesses, or as a reward for having done so. It was also alleged that X was party to an agreement in terms of which a French arms company would pay R500,000 a year to Y in return for Y's involvement in shielding the French company from a probe into aspects of an arms deal, and later promotion of the company's business interests in South Africa. 56. There was no dispute about the actual payments made by X to Y. The only issue that arose was whether or not these payments were made by X with the intention of influencing Y to use the weight of his political OCE. He was the MEC for Economic Affairs in KwaZulu-Natal and Deputy President of the ANC, to protect or further X's business interests. The court found, on the facts, that there were several instances in which Y had intervened to protect, assist, or further the interests of X's business enterprises, and concluded that these showed both a readiness on X's part to turn to Y for help in his business affairs, and Y's willingness to give it. The court concluded that the payments were made by X with the intention of influencing Y to act in X's interests. They were made at a time when X's businesses could not afford to issue such payments owing to their financial position. Since Y could not repay the money, he could only satisfy the sense of obligation placed upon him by the payments by using his name and political OCE. Also, X blatantly advertised his association with Y to his business partners, being confident of the political support he would gain from the latter. The payments could also not be regarded as loans, because the arrangements surrounding them were too exible and made no business sense from the point of view of a lender. The court found that the arrangement was prima facie contrary to the good morals or legal convictions of society, and that there was no justification, i.e., that the requirement of unlawfulness was satisfied. X had also foreseen the possibility that Y would feel obligated through these payments to help him in his businesses, and continued to make these payments, aware that Y would respond this way. He, therefore, was found to have had intention in the form of dolus eventualis. X was convicted on both counts of corruption, and one of fraud, and appealed to the Supreme Court of Appeal, SCA. It dismissed his appeals on all counts and confirmed his conviction. Activity X is a leader of an organized crime syndicate. His main activity is to import drugs. He employs a number of mules that bring drugs into the country through the Johannesburg airport. X is aware that Y works in the security section of the airport. In fact, Y has told him that he is the head of security at the airport. X arranges telephonically with Y that he, X, will appoint Y's son in one of his legitimate businesses if Y will see to it that people who will enter the country the next week with drugs in their suitcases are not searched at the airport. Y, who is in actual fact only an ordinary security officer at the airport, agrees to X's request. However, it is impossible for him to arrange that these people are not searched. Unbeknown to X, the Hawks have attached an electronic listening device to the telephone in his house. X is arrested. Discuss whether X may be convicted of corruption. Point 14 Feedback. It is clear that X may be convicted of corruption. X erred to give gratification to Y to act in a manner which amounts to an abuse of power or illegal performance of his functions. The fact that Y did not in actual fact have the power to do what he was requested to do is irrelevant. A mere OER to give gratification is sufficient to constitute the completed crime. X's act was unlawful and performed with the required intention. 57 CRW 2603/16.3.7.6 Unlawfulness. This requirement is the same as the corresponding requirement for corruption committed by the recipient, and is as has already been discussed above. 6.3.7.7 Intention. This requirement is the same as the corresponding requirement for corruption committed by the recipient, and is as has already been discussed above. 6.3.8 Corruption relating to specie C persons. In terms of Section 4, corrupt activities relating to specie C persons are criminalized. As already mentioned, it is impossible to discuss in detail each of the specie C offences created from Section 4 onwards. Considerable parts of the definitions of these crimes, in particular the element of inducement, that is, the part of the definition that starts with the words "in order to act," in a manner, are worded exactly the same as the general crime of corruption in Section 3, which has already been discussed in some detail above. We will simply give a brief overview of some of these specie C offences. 1. Corruption relating to public officials. Section 4 creates an offence limited to corruption of public officials. Public officials are denoted exhaustively in Section 1. A typical example of such an OCHALE is a state OCHALE. 2. Corruption in relation to agents. Section 6 creates an OINS limited to corruption of agents. Corruption committed by business people in the private sector is criminalized in this section. 3. Corruption in relation to members of the legislative authority. See Section 7. 4. Corruption in relation to judicial OCERs. Section 8 creates a crime limited to the corruption of judicial OCERs. The expression judicial OCER is denied in Section 1 and includes judges and magistrates. The conduct which the judicial OCER is induced to perform is also further denied in Section 8. 2. A typical example of this form of corruption is where someone gives a judge money or OERS her money in order to persuade her to give a judgment in favor of a certain party, conduct on the part of the judge that amounts to her not giving a judgment according to objective evaluation on the merits of the facts before the court. If someone corrupts a judicial OCER, the conduct can also be punished as contempt of court. 5. Corruption relating to members of the prosecuting authority. Section 9 creates an OINS limited to corruption of the members of the prosecuting authority. The act that Y is induced to perform is further denied. An example of a case resorting under this heading is when X gives Y, the prosecutor in a criminal case, money in order to persuade Y to destroy or hide the docket in which the particulars of the prosecution's case are contained so that it can be reported missing and so that the prosecution will consequently not be successful. The type of conduct criminalized under this heading can overlap with the common law OINS of defeating or obstructing the course of justice. 6. Receiving or owing of unauthorized gratification by a party to an employment relationship. Section 10 creates an OINS which is limited to corruption committed. 58. In an employment relationship. If an employer, for instance, accepts gratification as inducement to promote one of her employees, she can be charged with the contravention of this section. 7. Corruption relating to procuring of tenders. Section 13 creates an OINS limited to corruption committed in order to procure a tender. An example in this context is where X gives an amount of money to Y, whose task it is to decide to whom a tender should be awarded, in order to persuade Y to accept X's tender. 8. Corruption relating to sporting events. Section 15 creates an OINS limited to corruption committed in the context of sporting events. Someone who accepts or gives money in order to undermine the integrity of any sporting event contravenes this section. The word sporting event is further denied in Section 1. An example here is when X, who bets money on the outcome of sporting events, gives money to Y, who is a sportsman or sportswoman or a referee, in order to persuade Y to manipulate the game in such a way that the match has a certain outcome. 6.3.9 Failure to report corrupt acts. Section 34 creates an important crime which consists of failure by a person in a position of authority who knows or ought reasonably to have known that certain crimes named in the act have been committed, to report an OINS created in the act to a police OCER. Subsection 4 gives a long list of persons who are regarded as people who hold a position of authority. It includes any partner in a partnership and any person who is responsible for the overall management and control of the business of an employer. The form of culpability required is either intention or negligence, as a result of the use of the words who knows or ought reasonably to have known. In interpreting the word knows, the expanded meaning given to the word knowledge in Section 2 should be kept in mind. Apart from actual knowledge, it also includes the case where a person believed that a fact existed, but then failed to obtain information to confirm the existence of that fact. Willful blindness. 6.3.10 Extraterritorial jurisdiction. Section 35 provides that if the act alleged to constitute an OINS under the act occurred outside the Republic, a court in the Republic shall have jurisdiction in respect of that OINS. It is irrelevant whether the act with which the accused is charged amounts to an OINS in the country in which it was committed. However, the accused must be a citizen of the Republic, or ordinarily resident in the Republic, or must have been arrested in the Republic, or should be a company incorporated or registered in the Republic, or any body of persons in the Republic. Therefore, If a South African sportswoman participated in a sporting event in Japan and tried to influence the outcome of the match because a gambler owed her a sum of money to act in this manner, she can be charged in South Africa with one of the offences created in this Act. 6.